Good morning, Your Honor.
Good morning.
May it please the court. My name is Courtney Lutz-Creel, and I represent the appellant in today's case, David Fleming, who I will refer to as husband for purposes of argument. And I would like to reserve 5 minutes for rebuttal, Your Honor.
5 minutes, all right. You may proceed.
Thank you, Your Honor. Husband filed this appeal because the trial court essentially created a prenuptial agreement and awarded the appellee, Julie Fleming, attorney's fees without proper notice that fees were being requested. Additionally, the trial court failed to conduct a proper analysis to classify debt incurred during the marriage as either marital or separate, or to determine whether certain obligations that husband was ordered to pay were in fact a gift from wife to husband. This court should reverse the trial court's decision for 3 reasons. First, the funds that wife placed on the HELOC were a gift. 2, even if they were not a gift, the court attempted to make wife a creditor of husband and create a prenuptial agreement. 3, wife did not provide notice of her attorney's fees being requested or classified as a marital debt or alimony to be divided in the divorce. Turning to the first point, Your Honors, the funds that wife placed on the HELOC were a gift, and she should be responsible for them. In Davis v. Davis, it states as follows: courts have construed the distribution of marital property under Tennessee Code Annotated 3364121 to mean that gifts by one spouse to another of property that would otherwise be classified as marital property are the separate property of the recipient spouse. It also says that conveyance of property from one spouse to another creates a rebuttable presumption of a gift. In Lowry v. Lowry, the standard is set forth that 2 elements must be present for there to be a gift. 1, the intention by a donor to make a gift, and 2, the delivery of the gift, relinquishing the donor's control of property. To overcome the presumption, the donor spouse must prove that one of the elements isn't present.
Don't we have that here?
Well, Your Honor, I would state that in pages 66 to 67 of the record, the husband stated that there was a gift, and the court didn't apply that rebuttable presumption here.
Well, let's analyze what the trial court did, though, as
Yes,
I
Your Honor.
understand it, and feel free to correct me if I'm wrong. If I recall correctly in reviewing the record, the trial court basically said that she found the wife to be credible and the husband not to be credible when their testimony conflicted. Is that accurate?
That is accurate, Your Honor. However, I would state that...
Doesn't that basically do away with the thought process that this could be a gift? Because, as I assume, the wife says, this is not a gift, this is a loan, and the husband says, this is a gift. So the trial court had to choose which one it believed, and it, according to the specific findings, chose to believe the wife.
Yes, Your Honor. I would say that that finding is contrary to the record because in pages 11 through 13 of the transcript, wife specifically stated that she wanted to put the debt on the HELOC. She's the one that wanted that. And then we have an email that was found at Exhibit 10 that specifically states that she wanted to bear his debts. So even if the court made that finding, I believe it's contradictory to what's in the record. However, even if...
So are you asking us then to review the credibility determination by the trial court?
Yes, Your Honor.
Did you list that as an issue in your brief?
Well, I did not list that as a specific issue, but I did state that the court should consider that the findings were contradictory to what the court found, which was contradictory to what the evidence reflected in the record.
I do not recall. I recall I haven't seen it, but that doesn't mean that it's not there. But did you file a Rule 7 table?
I did not, Your Honor.
Are you aware that in order for the court to examine any distributions of property and debt, that a Rule 7 table must be filed according to the rules of the Court of Appeals?
I did not know that, Your Honor, and I'm happy to file that. But
I think we're a little past remedying that situation.
Yes, Your Honor. I'm happy to move on to my next point about the wife being considered a creditor, which I believe is a question of law. So looking at that specific issue, I believe the court can consider that. and that the court improperly created a prenuptial agreement. Because all we're looking at here is one specific debt, Your Honor, and it's the $20,000 debt that I'm asking the court to.
Isn't that the same thing we're talking about as far as property and debt?
Yes, Your Honor, but it's just this one issue, and I would say that as a
We don't
question.
have a Rule 7 table, do we?
We do not, Your Honor. So I'm happy to move on to the third point, which has to do with the attorney's fees, because I do believe that's something that the court can take up. And it's an issue of notice. So, Your Honor, looking at the third issue, Tennessee Rule of Civil Procedure 9.07 specifically states that you have to provide notice of special damages in your complaint. And in the complaint, there has to be a request for attorney's fees, and that's very clear in Hardcastle versus Harris. There must be at least a general request for attorney's fees. And alimony also must be requested or litigated upon adequate notice, and that's found in Anderton v. Anderton. 5 days before trial, wife submitted attorney's fees and requested that they be awarded, and that's found in pages 35 through 39 of the record. This was the first time wife requested fees as part of the trial, and she had not provided notice that she was otherwise requesting fees. She never requested them to be divided as marital debt, nor did she submit them timely before the trial to give husband the ability to determine whether he wanted to challenge this issue. It's also improper for wife to be awarded fees as alimony and solido. In doing so, the trial court was required to analyze the factors set forth in 36.5.121. And in Umstott v. Umstott, the court specifically held a spouse with adequate property and income isn't entitled to an award of alimony to pay attorney's fees and expenses. It's only appropriate when the spouse seeking them lacks funds to pay her own legal expenses, or if the spouse would be required to deplete resources to pay them. We don't have that evidence in the record here, Your Honors.
What findings did the trial court make regarding attorney's fees?
The court found, Your Honor, that they should be awarded as alimony and that was proper based on the findings. That's essentially what it is.
Alimony and solido?
Yes, Your Honor.
Okay.
And so the court classified them as such.
Did the trial court analyze the income and expenses of the parties to make that determination?
She did so generically, Your Honor. What she stated at page 56 of the record is that wife was in good health and had the ability to earn future income. So she actually made a finding that the wife had those abilities to make future income, that she was able to support herself, and yet still made a finding that these attorney's fees should be awarded as alimony and solido. And wife tries to use Creemans v. Creemans here to justify that, essentially stating, Your Honors, that, well, in that case, there was a statute that allowed the award of attorney's fees, and so that automatically puts the other party on notice. But that's not the case here, Your Honors. There is no statutory right to attorney's fees under this circumstance. Under TCA 36.5.103C, which would be the only, statute at issue, there is no specific award for attorney's fees with a divorce that does not include minor children. And additionally, the only other statute that would be at issue would be the one where the court would have had to analyze the alimony factors, and the court did not do so. So considering, and we would also argue that considering the amount in controversy, that the fees were unreasonable, we went through this in our brief, but wife's attempts to impede settlement and by essentially requesting that mediation be waived, and then ambushing husband at trial for a request for fees was wasteful and irresponsible, and we are asking that the court reverse the trial court for those reasons. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the court. I'm Hannah Ellis of the Williamson County Bar, and I represent the appellee wife, Ms. Fleming. I'm going to focus on the issue of the attorney's fees, and I'm going to start with the claim that the fees were awarded as solido when the trial judge analyzed them under 36.4.121BI and did those factors, and she did include all of those factors as well as the Supreme Court Rule 1.5 factors And so that is how she analyzed awarding fees, because they were an outstanding debt on the HELOC. And under the statute as was revised in 2022, marital debt now includes attorney fees incurred during the divorce. And so our position is that it was appropriate for the court to award attorney's fees as dividing it as a marital debt, which she had the right to do pursuant to 36-121.
So why is this marital debt?
I beg your pardon?
Why is this marital debt?
A marital debt?
Yes,
It was
why is it marital debt?
It was debt incurred during the marriage, and according to the statute that was revised, it reads, it includes debt incurred to pay attorney's fees and expenses incurred in connection with the proceedings, and unpaid attorney's fees and expenses incurred in connection with the proceedings through the date of the final hearing and proceedings brought pursuant to Rule 59. And Ms. Fleming put all of her attorney's fees on a HELOC and paid out of that. She testified at trial that that balance was nearly at its max, but that balance was still remaining. And so that was an existing debt at the time of the hearing, and the trial court acknowledged that in making her ruling.
And so did trial court then examine the respective financial conditions of both parties?
She acknowledged that both parties had work history, both had sufficient assets outside of this, and she did look at those factors, Your Honor.
Well, that's not necessarily the question I asked. Did she analyze those factors about the income ability of both parties, the health, and all those factors that go into consideration when you're analyzing pursuant to an alimony and solido situation?
She did analyze and specifically note that both parties were in good health. I believe she was looking at 36-121C, which is that more general provision, but she did acknowledge their education and the health of the parties. She found that they both had the ability to earn income, and they both had assets that could be used. However, the record is silent on what those specific assets were outside of the accounts introduced for Mr. Fleming, as well as the real property he owns.
Okay. And so why did the trial court award the attorney's fees then?
She awarded the fees, and she did go through in the statute the I factors, that the reason for the debt was wife pursuing the divorce, that the purpose of the debt was getting the divorce done, which she was successful. She was awarded the divorce on inappropriate marital conduct. And she said that the benefit was to both parties in that it was clear neither party wanted to remain married, and which party is best able to repay the debt. As I stated earlier, she acknowledged that husband did have rental income and that he was the party that was best able to pay the debt.
Did the trial court also examine the Supreme Court rules?
Yes, she did, Your Honor. She went through those factors, and the exhibit with the attorney's fees included them, but the trial judge did specifically go through those factors.
Where is that in the memorandum?
Let me pull that. On page 60 of the memorandum, she starts in analyzing the factors of RPC 1.5, 1 through 10.
What page, I'm sorry?
It is page 60 of the trial record, and it's 17 of her memo.
Page 17, okay. Okay.
Your Honor, the opposing counsel mentioned that there's no statute granting the court the right to do this, as been stated. She did mention specifically the 36 for 121, and so there was a statutory right for her to award those fees, and she did go through all 8 factors as well as the Supreme Court factors in determining those are reasonable. There's a focus on the amount in controversy. However, there are 10 factors, and when looking at them as a whole, that one doesn't erase the fact that the other factors weigh in favor of the reasonableness of the attorney's fees. And in asking that this court reverse and remand, given that this was heard by a judge that is no longer on the bench, that would mean most likely a whole new trial potentially. And given really the debt comes down, there's $20,000 in this debt that's in dispute, and then the attorney fees. And to go back would just not be in support of judicial economy. And we believe that the record contains sufficient evidence supporting the trial court's decision, and that the trial court's award of attorney's fees should be affirmed.
Thank you.
Just briefly, Your Honors, looking at the issue of the attorney's fees, we still have this issue of notice, Your Honors. There was no notice of any request for alimony, and the court specifically said that attorney's fees can be awarded as alimony in solito. There was no finding that wife was a disadvantaged financial spouse compared to the husband, and that she was able to sufficiently pay her assets. They were on her HELOC. And again, there was no request for these fees until 5 days before trial. And husband...
Let me ask you a question about this statute.
Yes.
Does the statute do away with the opportunity or the requirement that attorney's fees be awarded as alimony in solito?
Does it do away with it?
Yes.
It doesn't do away with it, Your Honor, as far as my understanding. I believe that's the way that statute would award attorney's fees in these circumstances.
It's just a mechanism to get there.
Yes, Your Honor.
Okay.
Yes, and they are considered a form of alimony. And so, again, we have this issue of notice. There was no notice of this. And even if it was classified as marital debt, which the court stated it was alimony in solito,
Was any alimony ever requested in the original complaint?
It was not, Your Honor. It was not. Alimony and attorney's fees, neither one was requested. There was still no notice. The parties have to provide one another adequate notice of what they're asking for at a trial, and that just didn't happen here, specifically with respect to the attorney's fees. And despite that, the court still awarded wife over $30,000 of fees, which we believe is improper, and that the court should reverse the trial court.
At what point did your client become aware that fees were being requested?
5 days before the trial, Your Honor.
Okay. Was an objection made?
It was, Your Honor.
Okay. Did the trial court rule then, or tell me the procedure there, please?
Yes, Your Honor. So at the beginning of the trial, based on the record, wife submitted an affidavit and advised the court that there was an affidavit of attorney's fees. And at that time, husband's counsel objected and stated that that was improper. And then the court, I believe, just said, okay, we'll just take that under advisement, essentially.
So in other words, there was there a supplemental petition filed? An amended petition requesting attorney's fees ever filed?
No, Your Honor.
Never a request for that?
No, Your Honor. I believe, and I do want to be fair to opposing counsel, I believe there was a request and a motion for attorney's fees related to a specific motion, but outside of that, there was no request for fees, and there was no amended petition filed. And wife had plenty of opportunity to do that, and she did not.
Okay.
So for those reasons, Your Honor, I would ask for the court, or the trial court to be reversed. Thank you.
Thank you. Thank you, counsel. We appreciate your briefing. We appreciate your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. Thank you, Your Honor. Thank you. That concludes the call of the docket for this morning. We'll be in recess to the call of the docket by the presiding judge.